running. You're running from this place to this next place and trying and sweating. It's just like this, it's like trying to share knowledge. It's always concentrated in February, right? Anyway, he is a model of the kind of scholar that I know many of you are striving to be. So you have to pay attention to him. A postdoctoral fellowship at USC. He received his PhD from the Department of It's actually African Diaspora Studies, right?
Yeah.
African Diaspora Studies at the University of California, Berkeley in 2014. He's got graduate degrees from the University of Pennsylvania, undergraduate degree from Northwestern University. He is an expert in the law. So he's about to accept a fellowship. I guess he already accepted a fellowship at Columbia University Law School in the fall, which is a huge deal. So he won't be with us on the West Coast. You may have read some of his essays on policing, on public policy, on debtors' prisons, poverty and law in Jacobin, Salon, Huffington Post, The Root, and many others. Or if you're like me, and you spend your time with your nose stuck in books like the Routledge Handbook of Poverty in the United States, which is like one of my favorite texts, uplifting, right? You might have noticed this chapter, A People's History of Legal Aid. The latter actually reflects his forthcoming book, which is titled The People's Champ, Legal Aid from Slavery to Mass Incarceration. And he's also beginning a project on public health in the post-1970 South Los Angeles period, centering on King Jude Hospital. So without further ado, we're going to hear Professor Ossei Owusu talk about the illusion of equality, race, nationality, and alternative configurations of legal aid. So let's join me.
For the kind introduction, and apologies again for being a couple minutes late. I prefer some pictures maybe like 10 minutes in when I but thank you, Don and Robin and Darnell, for inviting me, and thank you all for coming out today. So what I'm going to chat about today is a slice of my forthcoming manuscript, The People's Champ, Legal Aid from Slavery to Mass Incarceration. So I guess I should move over here because I may.
Do you want someone to click for you?
I can click.
We have a clicker, but
great. Okay, so I guess the next slide. So the People's Champ explores the historical development of legal aid organizations and public defender offices in the United States. And by legal aid, I'm referring to the organized provision of advice and counseling as it relates to substantive and procedural legal issues for indigent clients. And so before I start, an important factual point, next slide. The idea of a right to counsel, which is the Sixth Amendment, isn't a right up until the 1960s. And so until the 1930s, the Constitution is read in terms of negative liberties, or the kinds of things that government can't do or restrict people from doing. So, for example, the First Amendment, the government can't prevent the exercise of free speech or free religion. The Fourth Amendment, the government can't engage in unreasonable searches and seizures. And so as it relates to the Sixth Amendment is understood as the government can't prevent criminal defendants from obtaining an attorney, but not that the government has to provide some kind of affirmative obligation to give criminal defendants an attorney. And so starting in the New Deal, the Constitution begins to be read in terms of active liberties or positive liberties. So that emphasizes the affirmative role government should play in human flourishing and in citizenship. And so the Sixth Amendment began to be read in terms of how government can provide legal aid to indigent clients. And so the mainstream example is the Scottsboro Boys case, a 1931 case involving 9 boys accused of raping 9 boys of raping 2 white girls. And so they're railroaded through kangaroo courts and sentenced to die. The Supreme Court steps in and says the state has to provide criminal defendants with an attorney if it's going to take the defendant's lives. So in the Scottsboro Boys case, the federal government creates a right to legal aid in death penalty cases. So from the 1930s to the 1960s, the Supreme Court hems and haws on whether they want to extend that right to other felonies and misdemeanors, and this culminates in 1963 with the case called Gideon versus Wainwright, where the Supreme Court says if you're accused of a misdemeanor crime, the state has to provide you with a public defender. But for what I'm talking about today, the environment is a legal aid setting where there is no right to an attorney. So blacks, Latinos, Asian Americans either had to rely on philanthropic organizations or civil society to get legal aid, or they're representing themselves pro se in court. So that's important to keep in mind. Okay, so the next slide. So the larger project makes 3 interventions. Thank you very much. So the first is historiographical. And so part of what I'm arguing in the book is that legal historians are a century late when they describe the origins of legal aid. So usually they start with the Scottsboro Boys case that I just mentioned. Sometimes they start a little earlier with the development of the New York Legal Aid Society, which developed as a German legal aid society in 1876 and provided legal aid to German immigrants who were being taken advantage of by landlords and by employers. It evolved into the New York Legal Aid Society in 1896 and provided a template for other legal aid societies across the country. So starting in the early 1900s, you see legal aid societies develop in Philadelphia, Boston, Cleveland, Chicago, Detroit, etc. So that's what the history says. What I'm arguing is that legal historians are a century late, and that there are earlier episodes of legal aid that cohere around race, gender, and citizenship that are unexplored, and I'll explain that a little bit in the next couple of slides. So that's the first contribution. The second contribution is theoretical, and part of what I'm arguing here is that legal aid isn't just about an inability to afford an attorney, but it's deeply woven in these questions about race, gender, citizenship, age, sexuality, and again, I'll describe a little bit of that in the next couple of slides. And the last intervention that the larger project hopes to make is an argument that legal aid is part of the welfare state and part of the penal state in ways that have been under-theorized. So when we're talking about social welfare, oftentimes the discussion focuses on social security, education, health insurance, but legal aid rarely comes up in those kinds of conversations. At the same time, when people talk about mass incarceration, the focus is often, and rightfully so, on police officers, prosecutors, judges, sometimes tough on crime politicians, but public defenders often fall out of the purview despite being the only allies, in theory, of the criminally accused. So part of what I'm trying to do in the larger project is say, let's pay more attention to legal aid on the civil side and on the criminal side. Okay, next slide. And so here are some of the sources that I rely on for the larger project. So archival data, Catholic newspapers, court cases, briefs, personal papers. And this is a picture from one of the legal aid yearly annual reports from Boston. And it's interesting because Khalil Muhammad has this fascinating essay called Where Did the White Prisoners Go? And they're only in the archives because they're not in our popular imaginary. So here you have a public defender waiting for criminal people who are accused of crimes who are white in a Boston prison. Next slide. So I fell into this project because I was interested in public defenders, so I was reading up on the history about public defenders, and the standard account was the New York Legal Aid Society developed in the late 1800s. Other cities followed suit, and they provided legal aid to people irrespective of race and ethnicity. But given what I knew about the progressive era, I became very suspicious. So this is my favorite quote, the late Gary Coleman. I said, "What you talking about, Willis?"
Yeah, when I get that.
Yeah. So I do a little bit more digging, visit some archives, and I uncover this fascinating history. And so, next slide. And so, I do some archival research, some secondary research, and I find out about the Pennsylvania Abolitionist Society, which developed in the late 1800s late 1700s in 1775 and provided legal aid to fugitive slaves. So essentially what happens is Pennsylvania is one of the first states to pass the abolition law, and it's sandwiched and surrounded by states who don't pass abolitionist laws till much later. So what happens is black folks are fleeing to Pennsylvania, but also slave traders and slave hunters are fleeing there. And so there's this fascinating fugitive slave litigation that is being litigated by the Quaker abolitionists. Then on the right, this is the iconic picture of the Freedmen's Bureau. So the Freedmen's Bureau develops after the Civil War, and its goal is to provide legal aid and social assistance to blacks transitioning into citizenship. And Freedmen's Bureau historians have also written about some of the legal aid work that Freedmen's Bureau bureaucrats participated in. So they helped negotiated labor contracts for blacks transitioning into citizenship, sometimes for better, sometimes for worse. They dealt with contracts, they dealt with domestic violence and domestic abuse issues, and a host of other legal aid issues that have been unexplored in the larger scholarship on legal aid. And then on the bottom, this is a picture from Harper's Weekly in 1880. So the first two make up the content for my first chapter on pre and post slavery in legal aid. The second chapter talks about gender in legal aid. And so what happens is, after the Civil War, you see increases in female participation in the post-Civil War industrial workforce. And so these working women's protective unions develop in New York City and in Chicago, and this is mostly white women providing legal aid to working white women, and the goals of helping prevent them from being exploited from their landlords and by their employers. But eventually what happens is these working women's protective unions in Chicago and New York are taken over by the respective legal aid societies in New York and Chicago, and they kind of get obliterated from history. And it's only until recently that feminist historians are starting to write about it. And so part of what I'm trying to do in these first two chapters is to give historical evidence about legal aid cohering around race and around gender, to make this larger argument that it's not just about class. And so what I do from thereafter in the third and fourth chapters is say legal historians have still gotten it wrong, even where they start. And so they give this neat, nice picture about legal aid societies providing legal aid to people irrespective of race and ethnicity. But when you look in the archives, blacks and Latinos and Asian Americans are often missing. And so that's what the third chapter talks about, is the white mainstream progressive era background. And the fourth chapter talks about how blacks, Latinos, and Asian Americans created their own legal aid networks and institutions. And the fifth chapter picks up from the 1930s and thereafter and looks at the jurisprudential development of legal aid. And the final chapter looks at the post-civil rights movement and its relationship to mass incarceration. So that's what the larger project does. But now I'm going to talk about the progressive era. And so the 1900s are very important. Essentially what's happening there is there's a lot of fear about political dissidence. So in 1900, you have the attempted assassination of the Prince Edward of Wales. You have the actual assassination of King Umberto in Italy. President McKinley is assassinated. You have the Immigration Act of 1903, which tries to bar anarchists from the country, but doesn't really do a good job. And so another law is passed in 1918. You have the bombing of the Los Angeles Times building. And then after 1910, you have the Bolshevik Revolution, the Immigration Act, and the bombing of Wall Street. And much of this is attributed to Southern and Eastern Europeans. And so in the same ways that fears about terrorism are stereotypically applied to Arabs and Muslims, Italians and Polish immigrants and Americans are seen as the face of anarchism. And so the goal of legal reformers is to say, these Southern and Eastern Europeans are coming. They say these Southern and Eastern Europeans are coming here, and they see the legal system as illegitimate. And so we need to find ways to make them feel more like citizens and Americanize them. So next slide. I'm going to ask for some volunteers to read. Is that okay? Can I have a volunteer? Okay, great.
Did someone else raise their hand?
Okay, so this is...
I didn't want to leave you hanging.
No, so this is Romaine Hashford. He's the chief of the Legal Aid Bureau in Philadelphia.
So you want me to read it?
Yes, please.
Okay. Unquestionably, the signal benefit derived from the Municipal Bureau is its effect upon foreign-born applicants. Persons of foreign birth often view their government as an organization that restricts their liberties and that exerts a menacing influence upon them. This mental attitude is quite natural with a great number of foreign-born because their only contact with the government has been through the police department or through the prosecuting agencies. The Municipal Bureau of Legal Aid extends a protecting arm around the foreign-born, and this has been especially true in Philadelphia, where cases of persons of foreign birth are given unusual attention. They find in the Bureau, therefore, an organization which will fight their legal battles to the limit and insist that they shall receive protection from unscrupulous persons, many of whom are frequently of their own race who endeavor to victimize them. The direct result of this effort is better Americanism in the minds and hearts of the persons who obtained the benefit of such a person.
So quotes like this are common in legal journals, magazines. If you pick up a copy of the Harvard Law Review, Yale Law Review, American Bar Association journal, all the attorneys are writing in this kind of Americanization language. And the idea is we need to civilize and Americanize these Southern and Eastern American Europeans. Never mind that blacks and Latinos and Asian Americans are still experiencing these same kinds of discontent with the law. The idea is their daily threats in terms of robbery, in terms of rape, in terms of murder. But the idea with Southern and Eastern Europeans is that they're an actual threat to the polity. And so most of the legal aid attention is spent on them during the Progressive era. So the next slide. And so I visited archives in Chicago, Boston, New York, Philadelphia, and if you look at it, blacks, Latinos, and other racial minorities are often missing from the legal aid reports. They're not absent, they come up, but they come up very infrequently. And so there are three potential explanations for that. And the first would be race-based animus. That's unsurprising given what we know about this period. But if you look at the archival materials, no one's saying outwardly racist language. So I'm not necessarily sure that that's specifically what's operating, although I think that's what's happening in the background. I think what's more likely is racial discounting. And the idea is these European immigrants need our services more than Latinos and African Americans. And that's layered by what's happening with eugenics at this moment. And so the idea then is the reformers are focusing on who is considered to be redeemable. And that's also layered by what I mentioned before about positive versus negative liberties. So at this time, people who are accused of crimes are considered to be guilty. And so number one, why spend resources on criminal defendants generally, and that's what the legal aid reformers are fighting up against in the larger legal profession. But also the idea is that we're going to try to salvage anyone, let's salvage European immigrants. And so this is a picture of John S. Bradway. He's a legal aid reformer and a lawyer. He helps start legal aid clinics at law schools around the country, but he also helps draft a sterilization bill in North Carolina. And North Carolina, arguably with the exception of California, has some of the worst sterilization laws on the books. So here's an example of an important legal aid figure who is deeply intertwined with the eugenics movement. So the next slide. And so what did racial minorities do amidst this exclusion from mainstream legal aid? They just created their own institutions. And so this is a picture of Robert Abbott. Robert Abbott helped found the Chicago Defender. He was actually an attorney. He graduated from Chicago Law School, but he couldn't get a job. And his biographer says he couldn't get a job because he was dark-skinned. And so what he did was create the Chicago Defender. And some of you might be familiar with the Chicago Defender. A book just actually came out about it about a month ago. And most people, when they think about the Chicago Defender, they talk about its role in the Great Migration. And so the Chicago Defender was a big booster for getting blacks from the South to move up north. And they were letting people know about the promises of full citizenship and jobs that were available in the north. And so that's the typical conversation about the Chicago Defender amidst a bunch of other things. But often what's left undescribed is its legal aid column. And so from 1914 to 1917, they had a weekly legal aid column where people just wrote about legal issues that they had, and they got responded to in the newspaper. Next slide. And so in the larger chapter, I talk about the NAACP and some of its predecessors, mutual aid societies, the African American Church, which Du Bois and Drake and Caton write about as it relates to legal networks. I write about African American sororities and fraternal organizations, which Data Scotch Bowl has written about recently, and smaller organizations of black attorneys. But we're focusing mostly here today on legal advice columns. And so what's interesting is a lot of the people who start newspapers also have law degrees. So on the left, that's Robert Lee Vann. He helped found the Pittsburgh Courier, which was another popular newspaper at the time, went to Pittsburgh Law. On the middle, that's Ferdinand B. Barnett. He was the husband of Ida B. Wells Barnett, and helped found the Chicago Conservator. And then on the far right is William Calvin Chase, who helped found the Washington Bee and went to Howard Law School, but he didn't graduate. And so, next slide. And so it's also important to note that men weren't only involved in this. And so, on the far left was Anna Jones Robinson, who's the first African American woman to graduate from NYU Law, and she authored the legal hints section in the New York Amsterdam News. And on the right is Violet Anderson, who went to Chicago Law School and authored the legal hints to women column. So there's this fascinating archive of legal advice columns that's been underexplored, but today I'm focusing mostly on the Chicago Defender for time and because they had the most extensive legal advice column for a couple of years. And so Frederick Detweiler was a University of Chicago sociologist who studied under the famous sociology Robert Park, and he wrote his dissertation and his book about black newspapers. So this is a quote from his book. Can I have a volunteer?
The Chicago Defender seeks to live up to its title of Defender. Colored people from all over the country turn to it when in trouble. The staff interests itself in securing legal aid and justice for individual Negroes. In its role of champion of the common people and its aggressive advocacy of Negro rights, the press has found in recent years a pronounced welcome from its people. When Negroes have trouble of any sort, they write to the papers, sometimes merely to utter their cry for justice.
Next slide. And that's exactly what they did. So here are some of the issues that were in the legal advice column. And so they talked about criminal justice, labor, housing, child support, veterans benefits, consumer debt, employment, divorce, child custody. And here's a picture of Richard Westbrook, who authored the advice column. And so he also helped develop the Cook County Bar Association, which was the black counterpart to the Chicago Bar Association, which excluded black attorneys from membership. And so now for the next couple of minutes, what I want to do is look at some of the advice columns. Anyone, can I get a volunteer for this one? A little longer.
Well, I'll read the question and someone read the response.
Even better.
Okay, so I was arrested, charged with disorderly conduct in the trial in the municipal court at 35th Street. Now, before my case was reached or the court had opened, a policeman bought me a paper and stated that if I wished to have my trial at once, I should sign the paper. I signed the paper, and when the court opened and my case was called, I demanded the jury. But the judge said that I had made the demand too late, as I had waived my right to a jury trial. Now, please explain the law concerning jury trials to the state of Illinois.
And the response. We have noticed the actions of the police and others connected with the municipal court at the place you mention and other places where said municipal courts are held. And such practice is very common, and our readers are warned not to sign any paper presented unless you fully understand the contents of the same. The paper, no doubt, was a formal waiver of a jury trial, but you should have then and there explained to the judge why you signed the paper and the circumstances connected therewith. No person shall be imprisoned for non-payment of a fine or judgment in any civil, criminal, quasi-criminal, or quietam action, except upon conviction by a jury, provided that the defendant or the defendants in as such action may waive a jury by executing a formal waiver in writing, and when such waiver of jury is made, imprisonment may follow the judgment of the court without conviction by the jury. This section shall not apply to fines inflicted for contempt of court.
Okay, so here you have an example where they're saying, be careful what you sign. So it's a bookmark that. Next one. I'll read this one. To the defendant's legal helps. I'm a poor woman with two children who are very small, and I'm compelled to work each day for support of them and myself. I am informed that the state of Illinois has a law under which I can get aid from the county or courts. Will you please give me some information concerning the same? So response. Under an act entitled Charities passed by the legislature of 1913, upon a petition presented to the juvenile court or county court, a woman whose husband is dead or whose husband has become permanently incapacitated for work by reason of physical or mental infirmity, the said woman being a citizen of the United States and having resided in the county 3 years prior to the time of filing the petition, and who is a mother of a child or children under the age of 16 years old, upon a proper showing may receive a sum of money not to exceed $15 per month if she has one child under the age of 14 years old, and $10 per month for each other child or children under the same age, but no mother is to receive more than $50 a month. So this is an example of the attorney providing advice about obtaining welfare benefits. Okay, the next one, please. This is a shorter one.
I borrowed $25 from a loan company and promised to repay the same at the rate of $4.30 each payment until I had paid $38.50. I had paid $25.30 and I don't feel that I should pay them the $13.50 interest. Can the company by law collect the same? Answer, no. You are only required to pay the legal rate of interest, which in this state is 7%, and the company cannot by law collect any higher rate.
Okay, so we have a consumer debt example. Next slide, please. Great.
To the defender, legal helps. How should I vote on the amendment to the Municipal Court Act abolishing the grand jury in criminal cases? Answer, the great majority of the lawyers are opposed to the amendment for reasons too numerous to mention. First, it would jeopardize the liberty of the citizen and deprive the individual of the fundamental right of being tried upon indictments affirmed by his peers. Second, it would place the liberty of the individual citizen at the mercy of spiteful and malicious enemies and make it too easy to secure vengeance by the base use and power of the courts. Third, it would be especially against the colored people who, under this amendment, could be railroaded to the penitentiary without giving them an opportunity to prepare for their defense.
So, obviously, the grand jury discussion has changed a little bit, but that's an example of advice that's cohering around how to vote on a certain issue. One more? Anyone? I'll read this one. Question. My little boy was flying his kite yesterday out in front of my home when a policeman made him stop and told me that it was against the law to fly kites in the street. I stopped my boy, but not believing the policeman was telling me the truth, I would like information from your law department. The officer correctly informed you as to the law concerning flying kites in the streets or any other public place in the city of Chicago, and one is liable to a fine for $5 for each offense. And so this is the last one. Anyone?
You go ahead. Go. Okay. I can only read the question. I can't see the answer.
Okay, I'll read the answer.
Cool. My wife has refused to sleep with me for more than 2 years, yet I've provided for her. Now I desire to get a divorce. Is that sufficient grounds for the same?
There is no law compelling a husband and wife to sleep together in this state, and the same is no ground for divorce under law of Illinois.
Poor guy.
Next slide. So here are some of the historical takeaways. And so the first is that this legal advice column provided actual legal advice. And so we see this in the example with the welfare benefits, where the column is pointing to a specific statute that the inquirer can look to find out about what kind of welfare benefits she could get. And there are other examples that come up that I didn't show, but oftentimes they're about housing, they're about employment. And so you have people just saying, you know, I moved into this place, I gave my landlord 2 months security deposit, now he doesn't want to give it back. What do I do? And Westbrook points them to the specific statute that says this is the law you can rely on. This is the legal remedy that you have. And so what happens with the legal advice columns is that they're providing actual legal assistance and pointing people to specific statutes. And in some instances, Westbrook is responding to people and saying, you didn't leave your address. And so in the first issue of the legal helps column, they're saying you have to put your address or we're not going to respond. But in some instances, he's responding to inquiries and saying, I can't fully answer the question unless you tell me more, which suggests that there might have been more actual legal advice happening offline. But I have no evidence of that, but it's at least suggestive. So that's the first takeaway. The second takeaway is preemptive legal advice. And so we see this with the criminal justice example. And Westbrook is telling readers, don't sign anything unless you have an attorney. And never waive a jury because there's a high possibility that the judge is going to be racist. And so to be sure, a jury doesn't necessarily obviate racism, but it may disperse it. And he's saying the same thing in the context of consumer protection. So this is during a time where usurious loans are running rampant, and what he's telling people is be careful about what you sign and letting people know about their consumer protection rights. And so we see that with the interest example. And so here we see the advice column not only providing actual advice, but putting people on notice about the kinds of corruption that's rampant in the city of Chicago. Relatedly, there's the issue of civic education. And so we see this with the grand jury example and with the kite example. And so the column was often unabashed about its political views. And you see this with the jury example. But what they were trying to do was educate people about law, which is a very specialized field that the average person may not get all the nuances of. And so in essence, what he's saying, this is how law works, which is meaningful at a time when law is often not working in favor of African Americans. And the kite example also speaks to this civic education, as well as the kind of mundane legal issues that Black folks faced during this time period. And so at first glance, this might seem nominal, the kite is a kite example, but given the accusations around Black criminality and law breaking, as well as accusations about Blacks violating racial etiquette, something like that could help save someone's lives. I can see a scenario where a police officer telling my boy telling my boy to not fly his kite, and I can see myself getting into an argument, and that can lead into a host of different consequences. And so even the kinds of mundane advice that that Westbrook is giving can be useful to people. And I think there's often a tendency to focus on some of the heinous crimes that are committed against people of color, and rightfully so, because people died and these were exigent circumstances. But there were a host of other issues that Black folks were dealing with too, that we still deal with today. So employment discrimination, dealing with landlords, dealing with banks, child support issues. And part of what the advice column suggests is that we don't have to necessarily replace looking at some of these more serious crimes, but it can just serve as a complement. And so finally, there's the issue of self-help. And so for scholars of African American studies, this is just an example of the ingenuity of Black folks during this time period amidst exclusion, and how they've responded to such exclusion when civil society and the state didn't want to afford them with legal protection. Next slide, please. And so there are also some contemporary takeaways. And so again, just to emphasize the points about the larger project, there's a takeaway about legal aid not just being about class, but being tied up to gender, tied to race, tied to sexualities, tied to age, tied to citizenship. The second, again, is self-help. And so it would be hard to kind of replicate what the Chicago Defender did today, given these kind of complex rules that the American Bar Association has about how people can provide advice. But I think if you look at some grassroots organizations like the Arch City Defenders, the Bronx Offenders, the East Bay Community Law Center, these are examples of institutions, some of which were founded by whites, some of which were founded by multicultural founders, but they show that these organizations are focused on looking at legal aid as not just a class issue, but looking at it in terms of other axes of social identity. And I think the advice column shows that as well. And I think the final thing is about the importance of legal aid as a social welfare provision and as part of penal policy. And so, as I mentioned before, there's no right to a civil attorney in terms of housing or employment, but there's the Legal Services Act, which provides funds for legal services organizations. And so that's the Legal Aid Foundation of Los Angeles, for example, or some legal aid societies that don't do criminal work. So the federal government usually spends around $300 million a year on these organizations, which is a pretty small amount compared to other things the federal government spends money on. So that's what we have on the civil side. And then on the state side, for the last year that we have data, 2007, about $1.5 billion was spent on state public defenders, about $5 billion was spent on prosecutors, and $37 billion was spent on corrections. So the larger, So the larger point that I want to make is that here we have these constitutional and legislative imperatives in the background, and we're short-shrifting people for these imperatives as it relates to these imperatives, and it's impacting people's lives and their rights. And so in these larger discussions about mass incarceration, evictions, foreclosures, employment discrimination, we might want to pay more attention to mechanisms that might mitigate these issues. And I think legal aid and public defenders pose one potential solution to some of these problems. Thank you. I am sufficiently dry now.
Okay, so we got 15 minutes for questions, discussion. No one's gonna start, can I start?
Sure.
This is so fascinating, and I'm wondering about what's lost from those times when it was college. Because one of the differences, it seems to me, is that legal aid as an institution holds certain expertise. And so you go there, you get your assistance, you get your help, and they sort of take care of it. And here you're talking about the distribution of knowledge, so that there's a whole community now. They may not have expertise, but they still have a certain baseline knowledge. Do you see like a loss of generalized knowledge of the law as a result of the shift? And what do you attribute that to? Or maybe it's just
Yeah, so I think a yes and no. And so I would say yes in that and this is part of what I argue later in the manuscript. Once legal aid becomes more a function of the state in 1963, once the Supreme Court says this is a governmental obligation, part of what that does is trouble the natural adversarial process that's supposed to happen in legal aid. The idea is, in law, you're the prosecutor, I'm the criminal defense attorney. We're going to go to court, argue it out, and whoever has the better arguments win. And part of this is so that's part of that's not happening in mainstream society. And so, as background, I didn't mention is Los Angeles has the first municipally funded public defender in 1913. So a couple of cities that provided attorney, but no national requirement. So in the background of some of those cities, you see the same kind of collusion going on. But what you see you see it less here because we don't have litigation examples, but what you see with mutual aid societies and African American attorneys who are volunteering is a much more of an adversarial process because I'm not working with you. But once the state enshrines this right to a public defender, then you have the development of what some social scientists call the courtroom work group. So the judges, the clerks, the prosecutors, the public defenders, they're all working together, and it varies by the courtroom how much they're working together. In some courtrooms, public defenders don't like prosecutors, and they don't care if they're getting paid out of the same coffers. But in some places, they're working very collaboratively. And so I think that, to get to your question, I think that's what's kind of lost. And some public defender offices try to engage in know your rights campaigns just because the idea, and you see it with some of the institutions that I mentioned, like our city defenders in St. Louis, public defenders, they're saying it makes no point for us to just deal with the criminal consequences of our clients when they might get deported, they might lose their job, they might lose custody of their children. And so they try to engage in these kind of grassroots consciousness raising techniques. That tends to be more of the exception rather than the rule. So that's why I said no, but then I said yes still. So that's what I would say.
The question?
Sure.
In your research, going through kind of the advice columns, did anyone ever send or did they ever publish like an update saying, oh, thanks for telling me not to let my kid fly the kite, we avoided the fine, or like was there ever any information about the outcome of some of this advice?
So I didn't see anything about the outcome, but part of what they did is so there were three kinds of advice columns. And so the first was mostly what I showed today. The second was oftentimes it wasn't people even inquiring about a question. It was just like, look, this is a problem a lot of people are sending us letters about. These are the things that you should do. And the third was investigations. And so I didn't put it up here, but there's this long column where they're talking about the municipal courthouse, and they're saying this is the first in the series of investigations, and we're going to follow what's going on in the courtrooms, and if you experience discrimination, let us know about it. And so in terms of, your question seems to get about kind of like continuity. Mm-hmm. And so what you see is after that, people start sending in letters about what happened to them in the Cook County Courthouse. So that's the closest you see to that same kind of continuity. But that doesn't mean that it didn't get there. They might have looked at it and say, oh, well, we have space limitations, let's deal with something new. So, but I suspect that people probably sent letters thanking or giving Westbrook updates on what was happening.
In the 1920s, given sort of the global discourse and organizing around communism and the international communist movement, did you find any particularly black folks in Chicago that were talking and kind of built these organizations out of that theory as well, out of the idea of not just necessity but sort of like a class equilibrium type, or these social necessities are for everybody?
So I didn't see it in Chicago, but Du Bois has this article that's in the Pittsburgh Courier, which is I don't know, can you call them a competitor? They're competitor, but they have the same project. And so he has this article called Socialized Law in 1931. And pretty much what he says in this article is like, we need to have some kind of welfarist form of legal aid. So this is happening a couple of years before in the UK, they pass a law that provides legal aid to people, that provides civil legal aid. So in the article, he's talking about, let's look at these other countries. Let's look at Germany, because Germany is the one who brought the legal aid model in the early 1870s, at least in the institutionalized ways that don't include the Pennsylvania Abolition Society, the Freedmen's Bureau, etc. And so in the article, in this long article, he's detailing why law needs to be socialized. But I suspect that one of the reasons why you don't see it that much is because people fear being labeled as socialist or communist. And so there's the first Red Scare that comes from 1917 Bolshevik Revolution, and then there's the 1950s McCarthyist scares. But in between all of this, the American Bar Association is absolutely against any kind of legal aid system, because the idea is this is going to eat up our potential clients. And so you see these internecine battles within the legal profession where mainstream corporate attorneys are saying, no, we don't want this. This is intruding into the legal profession. And then you have, and it's saying this is socialist. And then you see on the public interest side, people saying, no, like, to avoid socialism and avoid people engaging in these anarchist acts, we need legal aid. And so the sense I get is that, black folks are interested in discussion, in that discussion. They're not wading into it as it relates to legal aid, although they are in other areas. But Du Bois is a popular figure who can kind of take that step forward and say, this is what we need to do.
I so want to follow up on that question with something, but before I do, anyone, this is your chance. So can I follow up on this?
Sure.
Because this is really, really important. So you started with Scottsboro case.
Yeah.
And as you know that
Yeah.
Scottsboro, they actually had lawyers, the
Yeah.
International Labor Defense.
Yeah.
So the International Labor Defense was precisely these groups of communists who decided, going back really to Sacrosanct Vanzetti, which were anarchists, to defend on their own what they call class war prisoners.
Yeah.
So how does, say, the ILD as an organization designed to defend specifically what they call class war prisoners, poor people, people who are labor organizers, and with Scottsboro, people who are black, not just Scottsboro, but all these people all over the country who would have had no legal representation at all, doing pro bono. How does the ILD fit in the project, one, and also how did the American Bar Association respond to an organization that's taking this work?
Yeah. So a couple things. So there's some interesting outliers in the project that I talk about. So I spent a good chunk of the 5th chapter. I start with the Scottsboro boys, and so you have the ILD, you have the NAACP, you have ACLU, you have the National Lawyers Guild, and so these are organizations that are providing legal aid, but they're selectively providing legal aid. So what you see with the NAACP, and it's fascinating because if you look at the social welfare directories for, like, the NAACP is listed as a legal aid organization. But when you look at their annual reports, they're saying, we're not a legal aid organization. Don't come to us just because you have a problem or because you're black. Come to us if you have a cognizable legal claim that might advance our legal campaign. And I don't get the sense that the ILD was saying the same thing, but I get the sense that they were doing the same thing, and that they were really interested in high profile cases that are going to advance their cause. And so then there's this background issue, which I'm not sure that I have the answer to. Like, if I provide opportunistic legal aid to you, is that legal aid? It is. But does it fall under the auspice of what we're describing? I would say yes, but I don't spend as much time on the NAACP and ILD for the same for that same reason. And you see the same thing happening with the National Lawyers Guild in the 1940s. And so, to respond to your other question, the ABA does not like it. The ABA doesn't like it, and even someone like Bradway, the guy that I showed earlier, he's an outlier because they really fear what's happening with socialism and communism in the country. Number one, they see the close call that happened in the medical profession when we almost got universal health care, but Truman wasn't able to get it done. And in the legal profession, they know that they're not as powerful and as organized as the AMA, so they're very worried, and so they're labeling the NLG, ILD, and any form of socialized legal aid as communist. And the only legal aid that they're comfortable with is pro bono work, corporate attorneys providing legal aid on their own time, but nothing organized in the kinds of ways that you see with the mainstream legal aid organizations.
Okay, we got about 3 minutes or so. Here's your chance.
For the current legal aid, how do you, how do you view that for today on and has it changed much, or has it in turn limit opportunities?
Yeah, so that's a huge question. I think, well, first I just think it's tricky because I'm in a community of progressive people who want to dismantle the penal state, the carceral state, and there's 2 ways of looking at it. The way I look at it is providing people with more attorneys who have less time, who can actually do their work and are not under-resourced and understaffed, will prevent people from going to jail. But some of my friends push me on this, and I disagree with it, but it's a legitimate concern. Their fear is if we hire more public defenders, we're just expanding the penal bureaucracy. And so it's tricky on what we can do in terms of public defenders. In my world, and I don't have the sophisticated mathematic economic background to create some kind of model, but to me it'd be interesting to have a TFA for public defenders. So in the 70s there was this program that was actually like that called the Reginald Heber Smith program, and essentially it incentivized public defense attorneys to go into public defense. And so these days, if you read the news, you hear about the glut of law school graduates, people who can't get jobs. But then if you look at the legal scholarship, you see all this legal aid need on the civil side and on the criminal side. So why not create some kind of program that incentivizes people to go into public interest law, and maybe you forgive their loans? And there are programs like that in place now, but those are organized by law school and not as a kind of national model. So I think for me the issue needs to be that there needs to be more defenders, public defenders, and they actually need to be able to do their work. So I think that's the first part. And then the second part is actually looking at the demographic background of who's doing public defense work. And there's not the best data on this. The best data on this is more qualitative, but it's oftentimes, so people of color are disproportionately represented in public interest work, but it's still predominantly a white space. And so oftentimes the kinds of people who can do this kind of public interest work are people who come from wealthy backgrounds. And that invites race, class, gender issues, certain kinds of paternalism. So I think we also need to find a better way of incentivizing more diverse groups of people to go into public interest practice, because I've worked in the public interest setting, and there's some very disturbing kinds of paternalism that you see with white attorneys, but that you also see with attorneys of color. And so for me, I would say the 2 issues first have to deal with staffing and resources, and the other has to deal with the demographic makeup of who does this work.
Well, with that, thank you so much. And look for your book coming out soon.
Hopefully, hopefully. Okay.
Thank you for coming. That was my question. It's like the aisle they didn't think the system worked. The whole thing is we're going to provide very often mass protection, knowing that this work with people like this trial. So that was
It's like kind of
they
like
made
yes. Yeah, no, they are. I mean, the debates around them are kind of early.
So can I just email you and we can schedule it?
I'm gonna email
I
everybody
think
and
they're
tell
pretty
everybody when the block is
people who are interested.
Oh yeah, no, that's fine.
Alright.
Thank you so much.
It can be useful. But the problem is, most people would take membership and they're like, oh, I can kind of do this on the side and make a little bit of money. And I think that's what this problem is. It is a pyramid scheme, but I think they can make money off of it.
And that doesn't really tell people in their cause.
Yeah.
It just makes money off other people.
Yeah, and in some states, the legal aid that's provided, in some states it's civil and criminal, in some it's just civil. So I'm suspicious of those models, but it helps with some people. I've known some people who use it not for criminal stuff, but for civil stuff, or traffic, and it's been helpful for them. But I think the problem with it really is the money.
And Sarah Haley, but that's in a different.
Oh, April 7th?
Doesn't say where it is, in a different location.